Hey, good morning.
Hey, good morning.
There we go. Hey, good morning, everybody. And afternoon, to some of you folks. All right, all right.
You're muted. We can't hear you.
Sorry, I was talking to them.
I just clicked it. It's the original one.
Got you. Sorry about that, everyone. I just called the moderator real quick so she can hop on and everything. There we go. Hey. All right. Well, good morning, everyone. Thank you all so much for being here, and sincere apologies for the delay. We had a couple of difficulties with regard to the invite and everything, but we're good to go now. We're excited for our discussion today. We have Charis Dorsey, the brand attorney. She's very experienced as it relates to intellectual property, retail, and brand development. She's going to be talking to us today about her experience, her background, and the different ways that you can think through intellectual property, retail, and navigating growth for your business. No one can tell your story like the host can, so I will turn it over to her to give her brief breakdown. But thank you so much for being here today, and let's get right into it. The floor is yours. Thank you. Oh, looks like you're on mute still.
Thank you so much, Ryan. I'm sorry about that for the introduction. I appreciate it, and I'm so excited to be here today. So hello to everyone. This is an exciting moment for us all, and I'm just here to just share a little bit about who I am and what I do and how I can be a resource to you, and just give you a couple of gems as you are going through the process of firming up your protections in the space, especially as a product-based business. Before I begin, though, I like to talk to people from where they are. So I want to meet you where you are. By a show of ones in the chat, just let me know how many of you are familiar with trademarks and copyright. And then also, by a show, we'll keep the same ones. We'll do, how many of you also have a trademark currently? Anyone who does not have a trademark or is kind of in the, okay, so pending, perfect. Perfect. Now I'm going to ask the second question. Since I've already used ones and I don't want to confuse anyone. How many of you hold trademarks for things beyond just your brand name itself? So you have trademarks for your products, you have other protections for your packaging. Let me know just kind of like where you are in that space. Okay, perfect. No judgment here. This is a no judgment zone. I do this as with the purpose of stretching your minds to think about your intellectual property, right? And thinking about the ways in which you can be protecting your brand as you go through, you travel this journey to retail, or if it is the case that you just want to keep things in-house, you may even want to do a brick and mortar, or just as you try to expand and have that global reach. I want you to just kind of think about how can you minimize your risks in your areas of exposure. So before we begin, I'll just give like a little highlight or a brief pathway or journey through what we'll be discussing. So I'll introduce myself and who I am, what I do. I'll kind of talk about some of the top risks for founders. And then I'll talk to you through the process of protecting your assets and give you some pro tips, especially as beauty and wellness founders. And then I'll open the floor up for Q&A. But I also say here, if you have a question that is burning in the midst of this, any portion of what I'm talking about, just drop it in the chat. And then we can discuss, but I would love to talk with you in greater detail towards the end. So who is a brand attorney? So I am Charis Dorsey. I'm an Atlanta native, born and raised, and attended Spelman for undergraduate and then Howard University School of Law for law school. I have been practicing for going on 8 years now. Initially went to law school with the purpose of focusing exclusively on beauty and fashion law during a time frame where that wasn't really a thing. And so have amassed a wealth of knowledge covering the gamut from just contracts to federal regulations, real estate transactions, and all of which essentially affect you. Now as of about 5-6 years ago, I started my own practice based here in Atlanta, but I serve clients, I would say globally, because I have clients both in the US and internationally, and I provide a unique niche of support to beauty founders and wellness founders in a standpoint of protecting the brand. And so what does that look like? It covers everything from the formation of the entity to the protection, so your registrations that you're most familiar with, your contracts, and the defense of your brand in the event that we need to defend it because someone has infringed, or that you need to actually explore international expansion into your brand if someone has already kind of beat you to the punch in that particular jurisdiction. So that is what I do, full scope firm here. But I love the way in which I have been able to marry beauty, wellness, and the law. So I kind of think of myself as like the nexus where beauty, fashion, and wellness meet the law. I cover and I reach and touch on those points with branding. I touch on those points with marketing and how those are the direct pathways to exposure for yourself. So yeah, that's who I am. I'm happy to be here. And now we'll kind of jump into kind of like the meat and potatoes of what we'll be discussing today. So I have basically broken down the top 5 areas of risk for beauty and wellness founders. The first is going to come with your brand name. So typically when we're discussing your brand name, I'll even put a slash there and add logos. And we're talking about the realm of trademarks and copyright. We'll discuss a little bit further on the next slide, but I'll put that here for now. The second place that I find for my clients as a big area for risk is around product packaging. So sometimes it can be something as simple as your packaging itself isn't distinct enough in a way that causes confusion on the marketplace, especially as you're showing up on the shelf, right? So if all of you are sourcing your product packaging from the same manufacturers, or you're kind of buying those stock print options for your packaging, sometimes it can lead to issues of confusion in the marketplace. So one of the areas that I like to, encourage my founders to think about distinguishing themselves is around product packaging. And so to that extent, we have trade dress, which is often a more silent resource for a way to protect the actual look of your products, whether that be from the bottle itself, it could be from the colors. We've seen with Tiffany blue. We see that color on a box, we automatically assume that it's Tiffany. If we see a red bottom on a shoe, we automatically assign or ascribe the brand to Christian Louboutin. So just thinking about the ways that you can, even for the Hermes packaging, Louis Vuitton packaging, when you see that color, you just automatically associate it. So how can you incorporate those type of, more subtle notes into your packaging and into your branding to establish exclusivity and protection in a way that gives you a wider reach of protection as a brand owner. We talk about, sorry, let's go back. Got a little bit ahead of myself. Product instructions. I never thought this would be a thing, but I have had quite a few disputes surrounding product instructions, product descriptions, even just the copy and how you describe the way in which your products will deliver on a particular claim. So utilizing or leveraging copyright is a great way in which you can protect yourself, but also it is a great, one of those subtle areas in which I have found a lot of founders run into issues, especially with their competitors. So if you have someone and you're a trailblazer in your industry, what will sometimes happen is that someone will use you as the model, right? And we love to say like, imitation is the highest form of flattery, but not to the extent that it becomes infringement, right? So product packaging, or not product packaging, but product instructions, and just the overall copy that you're using, that language that you're using, the way that you developed your brand persona, and have conveyed that through everything. So how you show up on the website, how you show up on your boxes, and so forth and so on, is something that has become a relative, I would say a relatively huge issue, especially in the beauty and wellness space. The other aspects I would say are going to be formulas. And so one part of this is going to be, if you are, well, I want to ask this question for those of you who use a chemist, please drop a 1 in the chat, because this is going to be something I may elaborate on a little bit more. But if you're someone who, went the private label route, that is completely fine. But formulas can also be a source of exposure, a source of issue for you. And when I'm talking about risk, I'm talking about risk from the standpoint of financial risk. I'm also talking about risk from the standpoint of ownership. So those are two components to be factoring or to be considering. The financial risk comes into play when we're discussing how can this brand potentially find itself in a lawsuit or having to expense a great deal of resources to reclaim the ownership of your intellectual property, or your brand asset, if you will. But formulas is one of those areas, especially where you're making modifications to a product formula that you do not own, or where you've sourced or have engaged and contracted with the manufacturer. And in the space of engaging with that manufacturer, have now found yourself or found that the manufacturer is reproducing or utilizing your formulas in a way that is infringing, especially when you are the original owner of it. So formulas is another area. And then the fifth area that I have seen frequently come up is around business relationships. So these are the third parties that you're dealing with, whether it be a business partner, whether it be a manufacturer, a supplier, an investor. This is one of those areas where it can lead to a great deal of financial exposure. So your risk is more so on the financial side there.
Just to chime in quickly, it looks like we have a question from Shamika. Any thoughts on product names and protecting that? Is that high risk?
Yes, I would put your product names kind of right there in between, like the brand name and the product packaging as well. Especially if you're I think of like Ruby Woo, right? Like we know that Ruby Woo belongs to MAC, but it has a life of its own. So anytime you hear Ruby Woo, you know that deep, beautiful red colored lipstick, right? That is something that if someone were to try to adopt, because I would consider it a hero product in space of MAC and their cosmetics. Because of how unique it is, it does open itself up to a space of infringement, no different than a brand name would or your product packaging would, because people want to mimic the color, people want to convey, and you'll sometimes even see it happen, color similar to Ruby Woo or identical to, or you'll even see a dupe of Ruby Woo. And all of those things, even when you see dupe of name of brand or trademark, even that can be a form of infringement, especially where it's still being utilized to promote another brand for commercial purposes, if you will. So yes, to answer your question, product names are a great source of risk for you as well.
And another quick follow-up, this came in via DM. For early stage founders that are starting to enter the market and develop some demand and build their brand name, should any of these risk areas be prioritized over the other if you're just getting started and you can't afford to lock everything in?
Mm-hmm. So I would say there are some areas where you're going to acquire what we call common law rights by way of use. So one of those spaces is going to be with trademarks. Now, I do not advise that you go in and you launch without, but I will say that common law rights and what a common law right is the rights that are birthed at the moment in which you conduct or carry out a business transaction. Got it. If I sell my lip gloss, and my lip gloss is Blue Sage, at the moment in which I sell my Blue Sage lip gloss to a person in Georgia, I've established common law rights to that geographical region. And then if I sell my lip gloss Blue Sage to someone in New York, I also establish common law rights to that territory as well. So while my recommendation is, of course, always secure trademark registration first, I would say at minimum, the things that you should prioritize is conducting a search to make sure that the name is available and eligible for registration. If it is a space where you're still you're kind of in that beta space, you're testing everything out, seeing what's going on, seeing how far of a reach you can get, because that establishes priority. In the event that you do have to come across or do come up against a trademark dispute in the future, you have priority. You can challenge someone who comes behind you and infringes. Now, of course, always best idea, best practice would be to file first, but that is one of those things. I would say starting out, trademark search, making sure the name is available, that you're not infringing on anyone, establishing your foundation. So making sure that you're separating yourself personally from the business itself. So you're getting that LLC or the corporation, you're making sure that your contracts are in place. And then we'll talk about that a little bit more in a moment, but making sure those contracts are in place so that ownership, all of your assets have a clear chain of title. We know who the source is, we know who the owner is, and then we're establishing that first. Before you go into any branding, so when I say branding, I'm talking about you're picking out your logos, you're picking out your colors, all of that. I would say then that is an important point to go ahead and file for that trademark, because you want to make sure that you have that investment there. And then from there, packaging, distinguishing yourself from a standpoint of packaging, all of that comes later. So I would put that second to doing the search, establishing the foundation, getting your contracts, filing the trademark. And then once you file the trademark, then you go on and start doing the actual fun part, which is the branding and choosing the scents and all of the other copy and things of that nature. So that's how I would go about it, for sure.
And thank you for laying out the steps there. It really makes a lot of sense.
No problem at all. So I kind of listed those risks for you, but now I want to just kind of talk to you just briefly about how do you overcome those risks, right? So the 3 ways or key ways that you can do this are through federal registration, contracts, and then federal regulation compliance. So one part that I didn't touch on the previous slide regarding formulas is sometimes where your formulas depart from the standards prescribed by FTC and FDA, you can find yourself also exposed to greater risk, financial risk, and potentially having your products pulled from shelves because they're not in compliance with the listing designations required by the FDA, or you're making claims that lead you to suits. So for example, let's say that one of the things that you're claiming is that you have a cellulite cream as an example, and in using that cellulite cream, the promise is that you'll see a transformation in 7 days. Someone purchases the product, uses it, doesn't get the results that they were after in 7 days. That's subjective, but doesn't get the results that they are after in 7 days, and then decides to sue because now they wasted their money. You promise something, you overpromise, and then underdelivered, and for that reason they're wanting to claim that your claim they're suing because the lawsuit. They're suing because the claims aren't accurate. That is an area which can lead you to a financial risk, because now you're pulling resources from your other business transactions to cover the dispute here. But in addition to that, sometimes that can also lead you to having your products pulled from shelves because of the false claims that are made. And then also not listing or not complying with other packaging requirements as prescribed by the FDA can lead you into issues as well. So making sure that you have who the distributors are, making sure that you have a manufacturer and address, making sure that your ingredients are listed properly. Those are some important and key things to be in compliance with, to avoid issues of impropriety in the future. But I would say beyond that, like the packaging regulations, the bigger piece is going to come around your claims. So making sure that if you're saying it's something, that it actually is in compliance with that. If you're calling it organic, it's in accordance with what the USDA defines as organic. If you're claiming natural, make sure that it's for all of your ingredients, not just some. So those are some of the ways that you can minimize risk there. Contracts, I have a whole slide on important contracts that you need as a beauty founder. So I'm going to hold off on that aspect for a moment, but I will talk a little bit about the federal registrations that are going to be useful. So as a business owner, you're going to be thinking about protecting the brand name, your product packaging, your product names. You're going to be thinking about protecting your copy, and those your product instructions, your content that you're creating. You're going to be thinking about protecting the photography that you also have. And most of those things are going to are going to be going to one or two agencies. One is going to be the U.S. Patent and Trademark Office, and then the other is going to be the U.S. Copyright Office. And so in that space, you just want to we'll map through what you have and where it needs to be, and creating. And I want to encourage you to start to think about, how can I, as a business owner, as a beauty founder, create a system around protecting these assets, and a system around continuously registering these assets, so that in the event that I do come across a challenge, I am fully protected before any dispute arises. And I will say that the beauty in having these registrations also helps with not necessarily always having to go to court. So one thing that I love, especially around having a trademark or copyright registered, is that if you come across infringing material online, like on social media, instead of having to go through great lengths to have it removed from, well, not have it removed, but having to issue a cease and desist and then having to take them to court, the registration is foolproof. So by submitting the registration to Instagram or to Facebook, they will remove the information or the infringing material immediately, avoiding the cost of having to take them to court. Now, if you want to also recover damages because of the sales that they made in the process, you're more than welcome to do so. But it is a tool or a resource that's available to you by merely having those registrations. So federal registrations, we're thinking the U.S. Copyright Office. We're also thinking the U.S. Patent and Trademark Office. Contracts, I'll talk about those a bit more in a moment. And then, of course, those, just ensuring that you're in compliance with those federal regulations as well. I saw a question in here. Would you say it is recommended to trademark your business name in general? Absolutely. And when I'm talking about your business name, I want to also distinguish, because sometimes you'll have a trade name which differs from the name that you actually present with. So like, for example, my law firm is the Dorsey firm, but I do business as the brand attorney. So in the space of what I have protected, I protected the brand attorney because that's the front-facing aspect of my business. And then I have not trademarked the Dorsey firm, mainly because it's a surname. It's much more difficult to protect the last name. And, I don't want to stop any other attorney who may share the same last name as me from being able to also utilize that name. I have less of a incentive in enforcing that as I do in the brand attorney as a brand itself. So you can kind of think through those aspects as well. But I do say that for the front-facing aspect of your business, or whatever you want to be recognized as, we think of L'Oreal, we think of McDonald's, we think of we think of Main Choice, all of these brands, like they may have Miel Organics, or in all of these brands, they have the overarching front-facing aspect of what the name will be, and then they have their product names, and those two are separate elements. Protecting both is important. Protecting Miel is important. No one asset is greater than the other in terms of protection, especially for you. The goal at the end of the day is to build an IP portfolio. And that IP portfolio is where you develop your brand equity out of. So that is essentially what establishes the value of your brand. And when you're thinking about things like even franchising or scaling, or like cross collaboration, and how one brand may receive an offer worth millions versus another for thousands. And the aspects of that come from, one part, the value of your assets that you own. I like to think of like Virgil Abloh, when he had his trademark originally, I think he was with a candle company, he's been able to take that same name and then, and shop it around and do cross collaborations with many other brands, for Off-White, with many other brands over the course of time, still maintaining ownership of that because the name itself had so much equity in it by just protecting the assets, building the asset up, marketing it, publicizing it. Over time, it becomes a thing that has value in and of itself, aside from the business model itself. And I think of like the difference between Target and Walmart, right? So if you go to Target and you go to Walmart, when you shop, you're essentially getting the same exact products, right? But what makes the difference between them is the brand itself. So you ascribe, Walmart is a valuable company in and of itself, but you ascribe a little bit higher value, or at least I do. Maybe I'm biased to Target, but it's just a little bit higher up, it's a little higher end. But that comes from the assets that it's had and the way that it's been able to cultivate brand awareness and cultivate a brand value, or cultivate or ascribe, if you will, well, I won't even say ascribe, to develop a reputation that lends itself to being able to appeal to the market in a unique way. So there's a difference between even a generic brand product as well versus a Tylenol. Tylenol is going to be looked at as a more premier brand, or the most legitimate brand, and that just comes by way of the marketing and just the overall reputation that it's acquired over time. But that brand name itself develops equity, and that equity can be leveraged over time. I don't want to label you on this, but overall, these assets, this brand IP portfolio that you're developing, it has a dollar value attached to it, whether we realize it or not. And what we want to do in this space is acquire as many assets and protect as many assets, cultivate as many assets that we can own as possible, to avoid to boost that equity in our companies, and to avoid instances of someone else being able to come in and kind of rest on those rights, causing confusion in the marketplace. So what should you be doing as a brand owner to secure your brand? I have on this side the contracts that you should have. So confidentiality agreements, and I put /NDAs. I distinguish the two for one reason. A confidentiality is a little bit more encompassing. So where an NDA is just going to say, I'm not going to disclose this information to you, a confidentiality agreement is going to have that non-disclosure language within it, but also non-circumvent language, meaning that someone who's coming in, who's been exposed to your proprietary information, isn't going to have the opportunity to come in behind you and poach, if you will, any of those key personnel or resources from you. So if you are, if your competitive advantage in the marketplace is your vendors or whoever your manufacturer is, you want to make sure that whoever is getting this, this insider information, isn't able to then go in and, poach those individuals for themselves. And in the same, you also want to ensure that you also have non-compete language in there. So they're not going to take this information by way, so they're sure enough, they're not disclosing it to another third party, but they're taking this information, receiving it, and then saying, this is actually a good idea. I want to do it for myself. So then they put themselves in the position of being your competitor. So contracts are going to be a big piece in having your confidentiality agreement just stretched out a little bit further to cover those areas as well is going to be important. So I want y'all after this to go in and just do like a contract audit to make sure that your agreements are a little bit more thorough. And if there are areas where you can, improve upon and firm up some of the terms within, then I want you to seek counsel and do exactly that. And then if you are already in a space where contracts has already been executed, there's typically nothing that stops you from filing an amendment to the original agreement, adding in additional terminology. So just something to think about there. Manufacturing agreements, those are pretty self-explanatory. You want to just make sure that it is clear what you're bringing to the manufacturer, whether that's your formulas, if they're your original formulas, that those aspects remain yours after the relationship concludes, if it concludes. Just making sure that there are certain specifications around timing. You want to just make sure that there are certain specifications in there just around even who the suppliers are and making sure that it's things are being developed in accordance and with the standards that you've implemented. One thing I have seen is manufacturers kind of do their own tweaks to your formulas or their own tweaks to the baseline products, maybe for performance reasons or another, but when you leave, they don't give you that information. So you want to make sure you have language and even within your manufacturing agreements to ensure that they're giving you that full disclosure at the end or throughout, actually. Operating agreements, partnership agreements, bylaws. This will more so depend on the structure of your business entity. So if you're you're using an operating agreement, typically that's for an LLC. An operating agreement is what I like to call your what if agreement. This kind of designates or spells out everything from the purpose of the business, how you bring in additional managers or owners in the company. It speaks to how you dissolve the business in the event that you no longer want to continue forward. If you decide that one day, hey, I'm tired of being in the role of operating the day or carrying out the day-to-day operations of this business, I want to offload that to someone else. You can speak to how you offload that and appoint another manager and what rights they hold within the role as a manager. Do they have the right to take out a loan on behalf of the business? Do they have the right to take out or to declare bankruptcy on behalf of the business as the operator of the business? You can kind of speak to that, even ownership of intellectual property. And if you're working with or have other business owners sharing in this entity with you, you can also speak to what is their capital contribution? How much are we showing up to the door with to get this business off the ground? And what is our commitment to refunding the business in the initial stages in the event that it needs more funding? And if you aren't able to do that, then what happens? Some of this language will also be reflective in the partnership agreement. Partnership agreements can be two LLCs coming together, two general individuals coming together. It doesn't necessarily have to be as formal, but an operating agreement is exclusive to LLCs. Bylaws are going to be more so exclusive to your corporations. So they all kind of carry the same function. It's just a different title for each one. Your employment agreements are going to be very important. I would put as a slash to this employment / independent contractor agreements, because sometimes you may be hiring someone in an unofficial capacity. So you're not paying the employment taxes. You don't have them as a on payroll and they're not W-2, but you still want to be able to speak to what ownership rights will be. So as they're coming in and they're leveraging or they're leaning in and giving you their insights, their intelligence, you want to make sure that certain aspects or certain ideas that they produce while this working relationship is established, that you continue to own after the relationship concludes. And then you're making sure that there's no some non-compete language in there, so they won't take this information and then go run off and become an employee of your competitor. It'll speak to the terms, their salary, so forth. And these are important agreements for you because of the risk associated with the financial risk associated with bringing in personnel. Licensing agreements. To the extent that you are working with third parties, maybe someone wants to collaborate with you. And so you want to have that licensing agreement in place, or maybe it's the case where you have some formulas that you're not necessarily married to the idea of being the front-facing aspect of the brand. So let's say you want to license your formula or let someone else use your formula, private label your formula, or white label your formula, if you will. License agreements can kick in here, but also licensing agreements can kick in where you are allowing a third party to promote or cross-promote a product for or with you. The licensing agreement will speak to how they can reference the brand. If there are certain guidelines that you have, for example, this came up once where I had a client who had a beauty brand, and they were contributing like products just as a gratis, and it was being promoted with another brand that sold weed. It was like for stoners or something like that. It was like, I think that was something stoners. It was something along the lines of that. But my client had a huge issue with that because her brand did not align with that. And so we wanted to make sure, and so in the licensing agreement that we had in place, it said that she had the right to review all media, all marketing materials prior to confirm that it was in compliance with their standards before releasing. Because they didn't, they were in breach. So licensing agreements are valuable, as well as brand ambassador agreements. So if you're going to be utilizing someone to promote your brand as an influencer, just making sure that you have that aspect clear. How many posts, what type of posts, when are they posting, when are they being paid, what happens if they create content that you don't like, how do you dispute that? And then the other piece that I want to highlight here, which will be also very useful for many of you, are trade secret agreements. So many of you will, and this is a question that's come up a lot, is how do I protect my formulas? Like, can I patent it? In some cases you can, but I don't know necessarily. My question or my turnaround to them would be, how long do you plan to be on the market in this space, taking up space in this industry, right? If your goal is to be like like a brand that holds longevity, it may not be in your best, interest to actually go in and register your formulas, or reveal that information, because that's your competitive advantage. How you mix your formulas together to yield the consistency that it has, that is your competitive advantage. And so instead of registering that where it becomes a part of the public domain, because that's what happens when you register something at the federal level, there's a trade that happens. You're telling them what you're protecting, and then they're putting the public on notice. And as they're putting the public on notice, it's nothing that stops them from seeing this idea, taking that idea, improving on that idea, and then becoming your competitor. So to keep that closer to chest, trade secrets are another option for you. And so it's more so, it isn't necessarily created or birthed through a registration, if you will, but it is birthed through you identifying what those elements are, and then creating safeguards around them, and then ensuring anyone who has exposure to them is bound by those trade secret agreements. And you can also put any of these things and combine them into a larger document. So for example, you can add trade, instead of it being a trade secret agreement, you can have a trade secret clause with an employment agreement, a licensing agreement within your employment agreement, trade secret language within your brand ambassador agreement, to the extent that they're being exposed in that way. But just something to think about as another option. And then also creating those safeguards. You want to think about who's getting exposure to this material, who needs to have exposure to this material. Does everybody need to know how to make this formula? And if not, then who does? Does everyone need to know who my specific power all-star marketing team is? And if not, then who does? You think about what your competitive advantage is and how it sets you apart from everyone else out there. It could be your email list. Like, that if you send out an email on Wednesday at 2 p.m., then you're going to have 300 sales. And you may have someone who's coming in as an independent contractor who may be, drafting up an email for you, who tries to take that email list. And then if they're going to work with another competitor, may say, well, I've grown out an email list. So I know how to get you sales. And really and truly, it's not the skill set of the writing itself, but the who you're reaching out to, these warm leads who are ready all the time, that actually gets the sales. That when he takes your email list onto someone else, that's what causes the harm to you. So you can protect yourself with agreements because that is also a trade secret. You can protect yourself in that space.
Can we make quick room for a couple of quick questions that we have? And actually, you touched on something really interesting with the trade secret. So I'm going to have something at the end of this in a second. But Shamika was wondering about trademarks, right? So could you trademark a generic name? Is it possible if you're first to trademark, even if the words are general? Can you talk more about generic trademarks? And Shamika, feel free to come off mute or throw more thoughts in the chat if I didn't do a good job of communicating.
I was referring to more so how there's challenges out here, there's courses, and there's all these other things that people are doing, but the terminology is very general, like the hair braiding course, the hair braiding challenge, things like that, where the words are kind of general.
Sure. So what we call those are actually descriptive marks. And so the way that the USPTO works, they have a spectrum. They have, on the weaker end of that spectrum, generic terms like the Apple brand for a brand that sells apples, right? Or the lash course for a course that's going to be about lashes. They're going to be on the weaker end. USPTO is typically not going to be as inclined to issue a registration for those generic terms. little bit further up on it, on the spectrum, are going to be your descriptive marks, which could be the lash, like the Lux Lash course or something like that. USPTO is also typically not going to be as inclined to protect those because it's not so hard or so far-fetched to believe that someone else could come up with that on their own. And so in the space of registration, they're going to be leery to protect or register a descriptive mark. They're not going to register a generic mark, but they're going to be a little bit more leery and more hesitant to protect a descriptive mark, but will in certain instances do so if it is found to be, if you can prove that you have acquired inherent distinctiveness. So you've been marketing it. So to the extent, like for the example, the brand attorney is a descriptive mark, but it was one that was necessary because sometimes it makes sense to do so, right? The brand attorney is considered a descriptive mark, but because of the way that I have branded it and have created like recognition around it, when people hear the brand attorney, they think of or associate it with my brand versus just a general term for what I do. But that has come through press, that has come through marketing, that has come through just general brand awareness over time. So in certain instances, you are able to get registration for a descriptive term, but what they'll typically do is put it on the supplemental register, and then they'll give you essentially like 5 years, and after that 5-year period, unless you can establish that you become distinctive even before then, they'll give you a window of 5 years, and then after that, it can be registered on a principal register. But above and the stronger marks on the spectrum are going to be your suggestive marks, which would be like Burger King, where you're not going to go in and actually meet the Burger King, but you know it's somewhere in the realm of burgers. So it's suggestive. Higher up though, in the place that you really want to be as a brand owner, as a founder, are going to be your arbitrary and fanciful marks. So your arbitrary marks are going to be like words that have an actual meaning, but when connected to the goods or services, creates brand new meaning. So like apple for computer, apple is a word, apple is a fruit, but connected to a computer creates brand new meaning. And because now when you hear apple, you actually have to ask yourself, wait, are you talking about apple the fruit, or are you talking about apple the phone? It's developed itself as a strong mark. And even higher than that are going to be the marks that are made up. So like we think of Xerox, Exxon, has no textbook definition, but when connected to the good, it creates the meaning, right? And so every time you hear Exxon, there's no question about what you're talking about. You know Exxon gas, you know Xerox printing. So that is a space that you would really like to be. And I think as beauty founders, there is so much opportunity to take advantage of that resting in that higher end of the spectrum. Like Miel, it may be a surname or maybe a first name, but it kind of lends itself to being almost fanciful. Like it doesn't really truly have a textbook definition meaning. So it's unique in that space. If you made up a word and it's cute, it's catchy, it's going to be more remarkable. It's going to be it's going to be easier to be protected, easier to defend as a trademark attorney, as a business attorney, easier to defend when it's more unique than it would be if you had something like Nature's Organics. And also think about it too, when you are choosing, especially for your product names or even the brand name, if you decide to rebrand, think about it too, like those beyond just the name overall, but those individual components, if those are like diluted names, so saturated names or words that are constantly being used, like nature, organic. I clearly have a personal vendetta against those two words, but nature, organic, gloss, boss, those kind of like those terms that you hear all the time in the industry, they're almost like industry terms. If and where possible, thinking about kind of veering away from those to create a little bit more distinction for yourself in a crowded marketplace. But no, you can't protect generic. You can protect descriptive with some caveats in it. Suggestive, arbitrary, fanciful are going to be the more ideal space to be in.
Appreciate it. We have a couple of other questions. Chinene, do you want to come off mute?
Sure. Can you hear me?
Mm-hmm.
Yeah.
Okay, good. So, hi, good afternoon. In terms of like what you were just saying, I recently saw like a candle company trademark things like zodiac signs and cities. How enforceable will that be for them to actually be able to use that going forward? And if a brand wanted to start incorporating zodiac signs or city names into their packaging, would they be at a disadvantage because this other company has trademarked these names?
Sure. So zodiac signs is going to be it's going to be treated a little bit differently than like a city name. City names are going to have additional concerns around or potential challenges around demonstrating that the name of the brand isn't geographically descriptive or geographically misdescriptive. In that space, they're going to want to know if the name is that you're using for the product is to convey that this product is derived from that particular region. And if the name or the city name is already, it doesn't even matter if it's already widely known, because they'll even protect even the most nuanced of a city or unknown, unrecognized of a city name as well. But city names are going to be a lot more difficult to protect. I'll put it that way. And just because of those two aspects, they're going to want to give people the right to, they don't want to give anyone a monopoly over a city name. Put it that way. Zodiac signs are going to be a little bit different because it can potentially fall into the arbitrary space or arbitrary end of the spectrum. So like if you had Cancer for a lip gloss, or Scorpio for a foundation palette. Well, Scorpio isn't a word that's a traditional industry term. But when you create or you're using Scorpio, which has a general meaning in connection with this, it creates a completely unrelated but remarkable, unique name in the standpoint of registration, especially where you're not selling like, it would be one thing if you were selling like Scorpio or the Zodiac Cosmetics and you're selling a Scorpio palette, eyeshadow palette for Scorpios. Then you get into some spaces where it kind of it goes back down the spectrum. So it's how you're using it, because if it's Scorpio palette for Scorpios, it's marketed for Scorpios, it's supposed to help you reach your channel your higher or the most dynamic version of your Scorpio self. And that's what you're alleging. You're also going to possibly have some claim issues with that. But if that is what you're alleging, the USPTO will say, well, in that space, actually, you're using this as a descriptive mark. So it's targeted towards and developed for Scorpios, and in that way, you can't use it. So it just depends on how it's being used. If it's just one zodiac term, and it's just being used in a way that is arbitrary, like the word Scorpio is just because you like the word Scorpio, and it's not to market it towards Scorpios, it's not to convey that you're channeling your Scorpio traits or anything like that, then in that space, it can be registered. But many cases, what people end up doing is shooting themselves in the foot. No, I don't laugh at me when I say that, but the terms and the copy that they use to describe the product ends up leading it towards it just showing, hey, this is actually just being used as a descriptive mark. So I hope that answers your question.
Yes, it did. Thank you.
Mm-hmm. And then so I've talked about the registrations in essence here, but I do want to wrap it up with a couple of tips for you. And then if there are a couple of more questions, we can kind of, I'll answer those as well, but I just want to be mindful of your time. But I have listed here, just a couple of tips. I have about 10 of them, and I'll go through them quickly. But I would say just following up on the point I just made before, choose unique product names for your brand and register them. Check agreements to ensure that no assignment language is present in your agreements. Assignment language is it's basically going to be any language that transfers ownership of an asset that you own to someone else. I've seen this happen oftentimes in production agreements. So if you're maybe like doing some type of reality TV show or some type of media or even manufacturing agreements too, but it may say that by you entering into this agreement, you're transferring your ownership to us. You just want to make sure that that language is not present. As a way that people oftentimes lose their rights. So just something to be mindful of. Verify ownership rights with chemists and manufacturers. So if you are going and you're engaging a manufacturer, you just want to make sure you're always asking the question, or a chemist, you want to always make sure you're asking the question, who owns this at the point in which I take this and bring it to market? Is it you who own it? Are we co-owners in it? Or do all rights rest with me? And make sure that that aspect is clear. Confirm you own or license the image. Confirm whether you're owning the images or licensing the images from your photography shoot. So if you're hiring someone to do product photography for you, sometimes what they're issuing to you is a licensing agreement. So at the point in which someone like a major publications reaches out to you to go to print and feature your product, the photographer may want any royalties or any payment compensation from that, and also may want specific credit. I have seen it happen on a couple of occasions where someone skipped out, went to print in a major publication, did not get permission from the photographer, actually only had a license to the images, and then was therefore sued. So, just making sure you own those images is something important. This leads to a whole thing around copyright issues. So just making sure you own it, or if you don't own it, understanding what the extent of your license is. Ensure packaging and marketing materials are in compliance with FTC and FDA regulations. We've kind of talked about that before. Create a separate entity to own your intellectual property. I would say that this is as you continue to grow and you develop more assets, I would say that it is also a wise idea to separate the entity who owns the intellectual property from the entity that is conducting the day-to-day operations of the business. And the reason being, you carry much more risk as you're conducting day-to-day activity from the business. So when you're making sales and transactions, there are the risks that come from someone utilizing a product and the product may be faulty. They may sue. Marketing, FTC, FDA issues that may come up, claim issues, contractual issues. And what you don't want to have happen is your intellectual property, so the assets that you own, to be potentially up for grabs because of a dispute related to the operations of the business. And then keep receipts of your important transactions. The first sale in the US, from state to state, keep all of those transactions. You never know when they're going to be useful, but just keep track of those. Conduct trademark searches before you start the packaging process. So do not, to the extent that you can, I would highly recommend that you do not brand or put any product names on any packaging until you at least confirm that no one else knows the name. And also that, and I would also recommend you file it first. I will also add this to the USPTO. So the trademark standard is not for an identical mark. So when I say that, what I mean is the USPTO is not enough that your own name is eligible for registration because no one else has that exact iteration of it. The USPTO also cares about similar names. So let's say that yours is, your name is Ben's Chili. I don't know, I was just looking at something earlier. Ben's Chili is the name of your brand. If someone else has Big Ben's Chili Bowls, or Ben's Best Chili, those other aspects, those names are also going to still be considered confusingly similar to the mark, because Ben and Chili are the two most prominent aspects of the original trademark. So I would highly recommend engaging an attorney to do that trademark search for you. But before you put anything on packaging, conduct that trademark search first. I'll also say conduct routine contract audits to ensure that your deliverables are being met. And then the last thing I'll add to this is going to be monitor your brand online and issue notices where you see infringement present. The way that the standard goes, you snooze on your rights, you essentially will lose those rights. So where you see infringement, don't rest on it because it's uncomfortable. Engage an attorney, or get a template, or find someone who's on your team who isn't afraid to confront someone and send those emails out on your behalf, but you want to acknowledge and nip infringement in the bud as you see it. And when I say monitor your brand, check social media, check Google. There are some brand monitoring agencies out there that you can also use. So monitor it. I would say monitor it routinely, make a habit of checking monthly at minimum, just to ensure that there are no other infringers coming out utilizing your name. And then, okay, I'm gonna stop now with the tips and I'm gonna open up for questions. And then Ryan, if you let me know how I'm looking on time, I know I'm like 2 minutes over, but if you let me know if I have a couple of minutes to answer these questions, or if not, then I can just follow up and feel free to, I can leave my contact information and then we can answer those questions offline.
We will unfortunately have to wrap up. Thank you so much. It was a very, very informative, great session. We thank you so much. Everyone, we're gonna display Charis's contact information, and I'm gonna relay some of these questions in the chat over to her. Really sorry we can't go over. Sometimes we have a flexibility, but today is just not one of those days. But I'll be sure to relay those questions over to her, send out the contact information. And if it's okay, would you be fine if we shared the deck with folks, or
Sure, absolutely. That's totally fine.
we're also going to be posting this in the app over the next week, so be mindful if you want to go back and review everything there. But thank you all so much for attending today's session. It was great. We look forward to the follow-ups, and I'll be sure to connect you all as needed with our great speaker today. So have a great weekend, and looking forward to the next session. Thank you.
Thank you so much. Thank you.
Just downloading these questions.
No worries.
Amazing job. Such a great job, by the way. Very
Thank
thorough. Shouldn't have
I'm
expected anything different. You are an attorney is all, but it was very, very informative.
Thank you. Thank you. I was like, I knew that if I tried to incorporate anything about the retail aspect, I definitely wasn't going to be able to make the time, but I'm glad to come back and if need be, and, elaborate on anything, because I do think it is valuable, and yeah, happy to be a resource, however you need me.
Thanks so much. I'll be sure to follow up with some of these questions and touch base. Have a great day, and you will hear from me soon. Talk
Okay,
soon.
thank you so much, Ryan. I appreciate it.